there! Thanks for joining me while I provide us an update and give current status of Jared Leisek's court hearing on Friday that just passed. But first, here's just a quick overview of what has transpired thus far. Jared Leisek is a founding member of the Bend, Oregon-based search and recovery dive team Adventures with Purpose. Jared Leisek was arrested and booked on January 5th, 2023 into a Sanpete County jail in Utah on one charge of child rape dating back to the year 1992. Leisek was released after no bail was set and does currently remain free without bond. The arrest stems from Leisek being initially charged back at the end of November 2022 with 2 counts of child rape against the same victim. However, since then, that second charge has been dropped. According to Deputy County Attorney Eric Buter and another officer's misreading of the victim's witness statement initially, the second rape actually occurred in the victim's grandparents' house in Las Vegas, Nevada, not Manti, Utah, as initially thought. Charges cannot be filed for a crime that did not occur in the Sanpete County of Utah, said the Deputy County Attorney. So, moving along to a December 12, 2022 court hearing, where Leisek's attorney Randall Richards filed a motion to dismiss all charges, which subsequently the court records were sealed for. Now, a motion to dismiss is simply a formal request for a court to dismiss a case in its entirety. This type of motion is filed when a party believes that the complaint is legally invalid. Now, let's fast forward to this past January 20th, 2023. Even with prosecution arriving in a fashionably late state, the hearing did finally get underway and lasted about 10 minutes. The court minutes include the prosecution filing its motion of response objecting to the defense attorney's December 12th motion to dismiss all charges. The scheduling of the next court date was set for March 8th, 2023. This court date is booked for what is known as oral arguments over the motion to dismiss. What does that mean? Essentially, the prosecution and defense will be showcasing some verbal posturing and doing the legal fandango of sorts. Well, I guess now is as good of a time as any to open up the prosecution's objection to dismiss the charges and go over it briefly and get an idea of some of the arguments that will be put forth.
In the criminal justice system, the people are represented by 2 separate yet equally important groups: the police who investigate crime and the district attorneys who prosecute the offenders. These are their stories.
Just before I start reading this, I probably should do my disclaimer shout out. I am not a lawyer. I do not have any formal training to be a lawyer, nor do I pretend to be a lawyer on YouTube. And we have the state of Utah versus Jared Leisek. The state of Utah, by and through counsel, and hereby submits the following objection to the defendant's motion to dismiss charges on due process and statute of limitation grounds. So, I'm not going to be reading all 19 pages of this motion. What I do want to do is I want to keep this relatively short, but I want to highlight and point out what I think are some key facts and important things that I found in this document. I'm just going to read the document and the motion exactly as it's written. I'm not going to be putting my interpretation or discussing how I see what's written, as I said, like my interpretation. I'm just going to stick to reading this document so we can keep this video relatively short and get all the information in there. Now, by all means, if you guys have any questions, need further clarification or anything of the sort, please just ask me in the comments and I'll be more than happy to help you out to the best of my ability. All right, here we go, guys. The introduction. Most of the defendant's arguments in his motion to dismiss rely on his allegation the incident could not have occurred in 1992 and must have occurred earlier. The state denies all such statement of facts and asserts, as it has in its charging document, that the incident occurred in 1992. The court cannot rely on the defendant's alleged facts to dismiss this case in a pretrial setting, as all evidence is taken in light most favorable to the state, and inferences are made in favor of the state. At this point in this proceedings, the only sworn statement before the court is that the incident occurred in 1992 as charged by the state. The defendant first argues there is a due process violation as a result of retroactivity and post facto application of the law. Full stop. I'm just going to give you a quick, I am going to interrupt for a second. I just want to give you guys an explanation as to what retroactivity and post facto application of the law is. I'm going to keep to myself how I'm interpreting that specific sentence. Once you guys, for those that may not be clear on what either definition means, once I explain it, then I'm sure you guys will come to your own conclusions, and we can talk about that at another time for sure. So, once more, the defendant first argues there is a due process violation as a result of retroactivity. Retroactivity is applying of a law to specific events that took place before the law was made. The defendant first argues there is a due process violation as a result of retroactivity and post facto application of the law. And post facto is basically retroactivity, applying of said law to the events that actually took place before the law was made, but that law is criminally punishable. So post facto is criminalizing conduct that was legal when it was originally performed or took place, then punishing those actions retroactively. So hopefully I didn't confuse you anymore. I have a bad habit of doing that, definitely not intentional. The more I try to make people understand things, seems to be the more I lose them. Anyways, carrying on. So this argument fails because the defendant could have clearly been charged with rape of a child in 1992 at the age of 16 or 17. Second, the defendant argues the statute of limitations has run. In 1992, for a charge of rape of a child, the statute of limitations would run 4 years after the matter is reported to a law enforcement agency. The matter was first reported to law enforcement in 2022 and has clearly not run. So it hasn't been 4 years yet. Next, the defendant argues that because 30 years have passed, some unknown documents may have been destroyed, and therefore this case is fundamentally unfair to the defendant. The defendant can cite to no case law that is applicable to this case and fails to acknowledge that the passage of time is far more detrimental to the state than the defendant. The state, having the burden of proof, is at a far greater disadvantage to proving its case because of the lack of physical evidence and loss of details regarding the crime. Lastly, the defendant argues that it is unconstitutionally unfair that if the defendant was convicted of this incident, he would face a significantly larger sentencing outcome than if he had been convicted as a minor. This argument also fails. Utah law clearly anticipates cases where an adult is convicted in a district court for a crime he committed as a minor, and the legislature has laid out several limitations on the court regarding sentencing. all of which ensure the defendant will not receive an unconstitutionally unfair sentence. So please just make note of that particular argument, that he feels he would face a larger sentence than as being convicted as an adult than if he had been convicted as a minor. However, Utah law shoots down the argument because it clearly states that in cases where someone is convicted of a crime that was committed when they were a minor, but they're an adult being convicted, this legislature lays out limitations that the court can apply in regards to sentencing. All right, so if we continue on, these next few pages have information about specific statements and arguments. So the defendant's statement of facts, and there's the state's statement of facts. Just let it be noted that in the state statement of facts, I noticed that there has been some specific instances from, do you remember the emails, guys? The communication between what was supposed to be Jared and his cousin, unfortunately the family member that he is accused of committing this heinous crime on. If you recall, a Reddit thread had released an email chain, a very self-incriminating email chain on behalf of Jared, that certainly doesn't paint him as a completely innocent person in any way, shape, or form. Anyways, those specific emails, that email chain, those emails were genuinely from Jared, and they have actually been submitted as evidence in this case. So I just wanted to make people aware of that. I know there was some discussion that, Jared wouldn't be stupid enough to use his Adventures with Purpose personal email to have this conversation, but apparently he was, or he just didn't care because he thinks he's invincible. But those were from Jared, and they have been entered into evidence. So just want to point that out. So again, we just are gonna, they just go over the arguments, the defendant making the argument against the applying of a law to this event because it took place before any law was created, and then the whole being punished retroactively for this law, but he was still charged because it says here, after it gives the Utah Code statute number, it was in effect having been first instituted, and we're talking about the charge of that incident towards a child. The law was first instituted in 1983 and remained unchanged since that time in 1992. So he can't argue that a law was created after 1992 for this event, because that's just false. So again, another argument of his is that the statute of limitations has run out. But here it actually points to the specific statute that indicates this kind of incident within 4 years of being reported to law enforcement does qualify. Not 4 years from the incident happening, but 4 years after reporting the offense to a law enforcement agency. And as I said already, this particular incident was not reported to law enforcement until recently in 2022. So well within that statute of 4-year limitations. And then again is the argument of the length of time between the crime itself and prosecution is not constitutionally unfair to the defendant. Him arguing it's fundamentally unfair to allow the state to charge him because he said there would be no police records or other records to substantiate the claim. This claim fails as there are current police records the defendant may use, and there were no police records at all in 1992, as the crime was not reported until 2022. Yeah, it kind of, some very peculiar statements are made in this argument of the length of time between crime and prosecution. As I said, I don't want to get into a debate or discussing that, because I mean we could just go on. As I said, I want to try and keep this short, but yeah, it's just some very peculiar suggestions as an argument. And then the other argument being that the defendant argues that Utah law prohibits prosecution of an adult for a crime that occurred when the defendant was under the age of 16 years old. In this case, the defendant's argument is moot because the state is not arguing that the defendant was under 16 years old. The state has charged the defendant for a crime that occurred in 1992 when that defendant was either 16 or 17. So, has nothing to do with nothing, and the defendant is incorrect. So, a lot of talking, but nothing that is valid and seems to stick. But again, I shouldn't be throwing in my take on it. I said I wasn't going to do that. So I do want to, there's one last thing that I do want to highlight that I think is very important, and this way people, if they don't know now, will not be shocked if this does go to trial. He is found guilty, and then there is sentencing imposed. So the defendant has been charged with the rape of a child pursuant to Utah Code 76-5-402, which is a qualifying sexual offense under the sentencing statute. It is incontrovertible the defendant can stand trial in the district court for rape of a child that occurred in 1992 when he was 16 or 17 years old. If the defendant, this is what I want people to take note of, if the defendant is found guilty after trial or a plea, this court is under certain sentencing limitations. So you got that. So, hypothetically speaking, Jared's found guilty, whether it goes to trial or a plea, this court is bound by certain limitations that were already laid out in legislation that I had mentioned up above a few pages further up in the motion. First, the defendant cannot be placed on the sex and kidnap offender registry if found guilty after a trial or plea. Second, so long as the defendant was between 14 and 18 years of age at the time the crime was committed, the district court shall impose a sentence consistent with the disposition that would have been made in juvenile court and not impose incarceration unless the court enters specific written findings that incarceration is warranted based on a totality of the circumstances. If the court does impose incarceration after making written findings based on the circumstances listed, then it may only sentence the defendant to 4 years incarceration. All of those factors combine to ensure that if the defendant was convicted of a crime he committed as a minor, the sentence would be constitutionally fair, but at least justice would prevail with the acknowledgement and official recognition that the crime occurred and the victim vindicated. And that brings us to the conclusion, which is based on the foregoing, the defendant's motion to dismiss should be dismissed and the matter set for a preliminary hearing. So there you have it. Now, if you guys don't think that Jared is bad and creepy enough, I'm going to close out today's installment with something that just might have you see him on a whole other creepy level.
Now, what I don't recommend, I don't recommend coming to the schoolyard during school hours when there's a bunch of kids around and you're 40 plus. Gonna look kind of weird. So anyway, now, what I don't recommend, I don't recommend coming to the schoolyard during school hours when there's a bunch of kids around and you're 40 plus. Gonna look kind of weird. So anyway,